The certified letter arrived on a Tuesday morning, and when Daniel Rodriguez opened it, his hands started shaking. Not from fear, from pure, unfiltered rage. After 9 months of documented harassment, 32 violation notices for a parking space he legally owned, and over $8,000 in threatened fines, the HOA president had just made the mistake that would end her reign of terror. She had filed a motion to have his vehicle towed and his deeded parking spot reassigned to her son. Where are you watching from? Please feel free to leave a comment below, as you are about to witness the most spectacular implosion of an HOA power structure ever documented in a residential community. This isn't just another parking dispute. This is the story of how one attorney's meticulous approach to documentation and one Karen's absolute refusal to acknowledge property law collided in a legal battle that would expose fraud, forgery, and a conspiracy that had been bleeding homeowners dry for over a decade. What the HOA president didn't know, what she couldn't have known because her arrogance had blinded her, was that Daniel wasn't just any homeowner. He was a real estate attorney specializing in property rights and HOA law, and he had been building a case that would not only destroy her credibility, but would result in criminal charges, a complete board dissolution, and a settlement so large it would make national news in legal circles. The parking space war was about to go nuclear, and the fallout would be absolutely devastating. Daniel Rodriguez had purchased his condominium in the Riverside Towers complex in downtown Phoenix 3 years earlier. The building was a converted historic property, a beautiful 1920s structure that had been renovated into luxury condos in 2015. The location was perfect, walking distance to his law office, close to restaurants and entertainment, and featuring the kind of architectural character that modern buildings couldn't replicate. The purchase price was steep at $420,000, but it included something that made it worth every penny: a deeded parking space in the building's secured underground garage. In downtown Phoenix, parking is gold. Most condo buildings charge $15,000 to $25,000 extra for a parking space, and many don't offer them at all. Daniel's unit came with parking space number 237, clearly designated in his deed, his title insurance, and every piece of closing documentation. This wasn't an assigned space that could be changed. This was a property right, as legally binding as ownership of the unit itself. The parking space had its own parcel number, its own tax assessment, and was explicitly described in the legal description of his property. For the first 2 years, everything was perfect. Daniel worked long hours at his firm specializing in commercial real estate law, with a particular focus on property rights disputes and HOA litigation. Ironically, he spent his days helping clients fight abusive homeowners associations, never imagining he would soon need to apply that expertise to his own living situation. His condo was his sanctuary, and parking space 237 was always there, waiting for him after exhausting days in court or marathon negotiation sessions. The Riverside Towers HOA had been relatively quiet during those first 2 years. The board consisted of 5 members, mostly older residents who had bought in when the building first converted. The monthly HOA fees were reasonable at $350, covering building maintenance, the front desk security staff, landscaping of the small courtyard, and reserve funds for major repairs. Board meetings were sparsely attended, and Daniel had never bothered to go to one. His assessment was paid automatically each month, he followed the rules, and he expected to be left alone. But have you ever noticed how quickly things can change when the wrong person gets power? The transformation of Riverside Towers HOA began in March of the previous year when Margaret Blackwood was elected president. Margaret was 67 years old, a retired office manager who had lived in the building since the conversion. She had run for the board multiple times before, always losing to more moderate candidates. But in the March election, voter turnout was abysmal. Only 18 of the building's 92-unit owners bothered to vote, and Margaret won by a margin of just 3 votes. Her first act as president was to appoint her 2 closest allies to fill vacant board positions, creating a voting bloc that controlled all board decisions. Her second act was to announce a comprehensive review of all parking space assignments to ensure they were being used appropriately and in compliance with community standards. This should have been Daniel's first warning sign, but like most busy professionals, he paid little attention to HOA politics and assumed the board would operate in good faith. Margaret had an adult son named Trevor, who lived with her in her unit. Trevor was 42 years old, unemployed, and, according to building gossip, had been living with his mother for the past 5 years after a series of failed business ventures and a divorce. Margaret's unit had come with one parking space, which she used for her own car. Trevor's car, a modified sports car that he was constantly working on, had to be parked in visitor parking or on the street, something that apparently bothered Margaret immensely. Visitor parking at Riverside Towers consisted of 5 spaces in the underground garage designated for guests. Building rules stated these spaces were first come, first served, and could not be used by residents for more than 72 consecutive hours. Street parking in downtown Phoenix was notoriously difficult, with most spots metered and time-limited. Trevor's parking situation was inconvenient, but it was the same situation faced by many residents who hadn't purchased deeded parking spaces. Where is this going? Margaret's comprehensive review of parking assignments wasn't about ensuring compliance. It was about finding a way to get Trevor a permanent parking space without having to purchase one on the open market, where deeded spaces in the building sold for $20,000 to $25,000 when available. The first indication Daniel had that something was wrong came 6 weeks after Margaret took office. He received a notice stating that parking space 237 was being temporarily reassigned for garage maintenance and that he should use visitor parking for the next 2 weeks. The notice was vague about what maintenance was being performed, but Daniel figured it was a legitimate issue and complied, parking in visitor spaces and enduring the inconvenience. 2 weeks passed, then 3, then 4. Daniel sent an email to the HOA management company asking when he could return to his designated space. The response was maddeningly vague. The parking committee is reviewing space assignments and will notify you when your permanent assignment is determined. Parking committee? Permanent assignment? Daniel's space wasn't assigned. It was deeded property. He owned it outright. Daniel pulled out his deed and reviewed the legal description. There it was, clear as day. Parking space 237 in the underground garage of Riverside Towers, with specific dimensions and location description. He reviewed his title insurance policy, covered. He reviewed his closing documents, all confirmed ownership. He sent a certified letter to the HOA management company with copies of all documentation, clearly explaining that parking space 237 was not an assigned space subject to HOA reallocation, but was deeded property that he owned. The response he received 2 weeks later was shocking in its audacity. The letter, signed by Margaret Blackwood as HOA president, stated that while Daniel's deed did reference parking space 237, the HOA had authority under the CC&Rs, covenants, conditions, and restrictions, to reassign parking spaces as needed to ensure equitable use of common areas, and that parking space 237 was being permanently reassigned to another resident. Daniel was being assigned parking space 184 instead. What would you do if someone tried to steal your legally owned property? Daniel's response was immediate and professional. He drafted a letter explaining in precise legal terms that the HOA had no authority to reassign deeded parking spaces, that such action constituted an illegal taking of private property, and that if his access to space 237 were not restored within 10 business days, he would pursue all available legal remedies, including injunctive relief and damages. He sent the letter by certified mail and copied it to every member of the HOA board, the management company, and the building's attorney. He assumed this would end the matter. No reasonable board would continue down this path once the legal issues were clearly explained by an attorney who specialized in this exact area of law. He was wrong. Margaret Blackwood didn't back down. Instead, she escalated. The day after Daniel sent his legal demand letter, he arrived home from work to find a large pickup truck parked in space 237. The truck belonged to Trevor Blackwood, Margaret's son. Daniel parked in visitor parking and went directly to the front desk, asking security to contact the HOA about the unauthorized vehicle in his space. The security guard, looking uncomfortable, informed him that the HOA president had instructed him that Space 237 was now assigned to Unit 412, Margaret's unit. Daniel went back to his car, documented everything with photographs showing the truck in his space, the space number clearly visible, and the date and time stamps. Then he did what any attorney would do. He began building his case file. Every piece of documentation, every photograph, every email, and every letter went into organized folders, both physical and digital. If this were going to escalate into litigation, he would be prepared. The next morning, Daniel contacted a towing company and had Trevor's truck towed from Space 237, as was his legal right as the property owner. The towing cost Trevor $280 to retrieve his vehicle. Within an hour of the truck being towed, Daniel received a furious email from Margaret demanding he reimburse Trevor for the towing fee and threatening him with fines for harassment of residents and abuse of parking privileges. Are you starting to see the pattern of escalation here? This wasn't going to be resolved reasonably. Margaret had decided that she was going to get that parking space for her son, legal property rights be damned, and she was willing to abuse her position as HOA president to make it happen. Over the next 3 weeks, Trevor's truck appeared in Space 237 6 more times. Each time, Daniel documented it and had it towed. Each time, Margaret sent threatening emails. The towing fees accumulated. Trevor was now out nearly $2,000, but neither he nor his mother seemed to learn the lesson. Instead, Margaret began issuing formal violation notices to Daniel. The first violation notice accused Daniel of creating a hostile environment through repeated abuse of towing authority. Fine, $500. Daniel responded with a detailed legal letter explaining that towing unauthorized vehicles from his deeded property was not abuse, but was instead the exercise of his legal property rights, and that he would not be paying any fine based on such an absurd claim. The second violation notice, arriving just 3 days later, accused Daniel of parking in visitor spaces beyond the 72-hour limit, despite the fact that he was forced to use visitor parking because the HOA was illegally denying him access to his own space. Fine, $300. Daniel documented the circular logic. The HOA was now fining him for the direct consequences of their own illegal actions. Can you imagine the frustration of being punished for trying to access your own property? The violation notices continued to pile up. Daniel was cited for having his vehicle visible from the street for extended periods. He had to park on the street when all visitor spaces were full. Creating aesthetic disruptions by parking an older vehicle in premium visitor spaces. His car was a 10-year-old sedan in perfect condition, failing to properly display a parking permit for a deeded space that didn't require a permit, and most ridiculously, causing a pattern of disruption to community harmony. Each violation came with fines ranging from $250 to $500. Daniel contested every single one through the HOA's internal dispute process, providing detailed legal arguments and documentation with each response. Every appeal was denied, usually with 1 or 2 sentence responses that didn't address any of his legal arguments. Margaret was rubber-stamping rejections, and the other board members were following her lead without question. Daniel decided it was time to attend a board meeting. HOA law in Arizona requires open meetings where homeowners can address the board, with limited exceptions for executive sessions. He reviewed the meeting schedule and RSVP'd to attend the next monthly meeting, following all proper procedures. The meeting was held in a small conference room in the building's common area. 11 other residents attended, a larger turnout than usual, as word had spread about the parking dispute. Daniel signed up to speak during the homeowner comment period and waited patiently as the board conducted routine business. When his turn came, he approached the microphone and calmly presented his case. He showed the board copies of his deed with the legal description of parking space 237, explained the legal difference between deeded parking and assigned parking, and explained why the HOA lacked authority to reassign his property. He pointed out that what they were attempting was legally equivalent to trying to reassign ownership of someone's actual condo unit. The parking space was equally protected property. Margaret's response was stunning in its dismissiveness. She stated that the board had consulted with legal experts who had confirmed the HOA's authority to manage parking in whatever way served the community's best interests. She claimed that Daniel's aggressive legal posturing was exactly the kind of behavior that disrupted community harmony. She then called for a vote to uphold all outstanding fines against Daniel. The vote was 3-0, with 2 board members absent. But what Margaret didn't know was that Daniel was recording everything. Arizona is a one-party consent state for recording, and HOA meetings are legally required to be open to members. Daniel had his phone on the table, clearly recording the entire proceeding. He had Margaret on record making false claims about legal authority, dismissing property rights without any actual legal basis, and demonstrating clear bias. Other residents approached Daniel after the meeting, speaking in hushed tones in the parking garage. 3 different homeowners told him they had also been hit with questionable fines for minor violations. One woman had been fined repeatedly for having a doormat that was allegedly the wrong color. Another resident had been cited for having blinds visible from the exterior that didn't match the building's aesthetic standards, a standard that didn't actually exist in the CC&Rs. A pattern was emerging. Margaret was using her position to harass residents and generate fine revenue. Daniel began documenting these conversations. He asked each resident to provide written statements describing their experiences with Margaret's board. Several agreed. He was building evidence not just of his own case, but of a pattern of abuse that could potentially support a class action or a broader legal challenge to the board's authority. The fines against Daniel continued to accumulate. The total now exceeded $8,000. The HOA sent a letter warning that unpaid fines would result in a lien being placed on his property. Daniel knew that under Arizona law, HOAs do have the power to file liens and even foreclose for unpaid assessments and fines, but only for legitimate debts. Filing a lien based on improper fines could expose the HOA to significant legal liability. Have you ever been in a situation where standing up for your rights just brought more retaliation? That's exactly what Daniel was experiencing. The more he pushed back legally, the more creative Margaret became in finding new violations to cite. It was clear that this wasn't about parking space 237 anymore. It was about Margaret demonstrating that no one challenged her authority without consequences. Daniel made a decision. It was time to go on offense. He filed a complaint with the Arizona Department of Real Estate, which has oversight of HOA management companies. He alleged that the management company was complicit in allowing the HOA board to violate state law and property rights. He filed complaints with the Better Business Bureau. He began documenting everything for a potential lawsuit. But he also did something more strategic. He started talking to other residents, not just about their complaints, but about organizing. Arizona law allows homeowners to call a special meeting if they can get petition signatures from 25% of homeowners. Riverside Towers had 92 units, meaning Daniel needed signatures from just 23 homeowners to force a special meeting where the community could vote on board removal. Getting those signatures proved easier than expected. Margaret's aggressive fine policies had created widespread resentment. Residents who had been too intimidated to speak up individually were willing to sign a petition. Within 2 weeks, Daniel had 31 signatures, more than enough. He submitted the petition according to proper procedures, calling for a special meeting to consider a vote of no confidence in the current board and the potential removal of Margaret Blackwood as president. State law gave the HOA 30 days to schedule the meeting. Margaret's response was to accelerate her attacks on Daniel. The violation notices became almost daily. Daniel was cited for things like walking through the lobby while wearing athletic clothing that didn't meet dress code standards, no such dress code existed, having a package delivered that sat in the mailroom for 4 hours before he picked it up, constituting aesthetic disruption, causing reputational harm to the HOA by filing complaints with state agencies, and most absurdly, conspiracy to undermine legitimate HOA governance. Each violation came with the maximum fine allowed under the CC&Rs. The total amount of fines now exceeded $12,000. And then Margaret made her most aggressive move yet. She filed a motion to have Daniel's vehicle towed from any HOA property and to have parking space 237 permanently reassigned to Unit 412. And that brings us back to that Tuesday morning when Daniel received the certified letter. The letter informed him that the board had voted to authorize towing of his vehicle and reassignment of his parking space, effective immediately. It also notified him that the accumulated fines were being referred to collections and that a lien would be filed against his property within 10 business days. This was the nuclear option. Margaret was betting that Daniel would back down rather than face a property lien and the complications that would create. She was betting wrong. Daniel's response to Margaret's nuclear option was swift, strategic, and devastating. Within 48 hours of receiving the letter authorizing towing and reassignment of his parking space, he filed a lawsuit in Maricopa County Superior Court. The complaint included claims for declaratory relief, confirming his property rights to parking space, 237, injunctive relief prohibiting the HOA from interfering with his property rights, violation of Arizona's HOA statutes regarding proper governance, breach of fiduciary duty by board members, intentional infliction of emotional distress, abuse of process. But those were just the public-facing claims. What made Daniel's lawsuit particularly dangerous for Margaret was what he discovered during his preparation of the complaint. When he pulled the official deed records for parking space 237 to attach to his filing, he noticed something odd. He then pulled the deed records for every parking space in the Riverside Towers garage. What he found was explosive. Parking space 237 wasn't the only space that had been reassigned by Margaret's board. Over the past 9 months, Margaret had presided over the reassignment of 7 different deeded parking spaces, always moving residents out of convenient lower-level spaces and always reassigning those prime spaces to board members, their family members, or their friends. The pattern was unmistakable, but it got worse. When Daniel cross-referenced the reassignments with actual ownership records, he discovered that in 3 cases, the HOA had issued new parking permits for spaces that were actually owned by specific unit owners, effectively allowing board-connected residents to use other people's deeded property without permission. This wasn't just an overreach of HOA authority. This was potentially theft by deception. Can you imagine discovering that a systematic scheme had been operating right under everyone's noses? Daniel expanded his investigation. He requested copies of all board meeting minutes for the past year, as was his right under Arizona's HOA disclosure laws. The minutes revealed that Margaret had frequently held emergency meetings with minimal notice, during which major decisions about parking were made with only her 2 allied board members present. These meetings didn't comply with the notice requirements of Arizona law, making their decisions potentially void. Daniel also noticed something interesting about the finances. The HOA's monthly financial statements showed a line item for parking management fees that had increased dramatically since Margaret took office. He cross-referenced these fees with the management company's contract and discovered that the management company wasn't actually charging any parking management fees. Those charges were being invented, and the money was going somewhere else. He submitted a formal request for all financial records, including bank statements, canceled checks, and vendor contracts. Under Arizona law, homeowners have the right to inspect HOA financial records. Margaret's response was to stonewall, claiming the records were confidential board materials and couldn't be released. This was legally incorrect, and it gave Daniel grounds to file a motion to compel discovery. The lawsuit filing made local news. A real estate attorney suing his own HOA over parking rights was exactly the kind of David versus Goliath story that resonated with the public. A local newspaper ran an article titled, "Attorney Takes on HOA Board in Battle Over Parking Space," which included quotes from Daniel about property rights and quotes from Margaret defending the board's authority to manage community resources. What Margaret didn't realize was that the publicity was the worst thing that could have happened to her. The newspaper article prompted a call to Daniel's office from an unexpected source. A former board member who had resigned in protest 6 months earlier, shortly after Margaret took control. This former board member, a retired accountant named Harold Chen, had disturbing information to share. Harold explained that he had raised concerns about financial irregularities during Margaret's first few months as president. He had noticed the same parking management fees that Daniel had spotted. When he asked about them, Margaret had told him they were legitimate charges from a consultant helping to reorganize the parking system, but Harold had requested documentation of this consultant's work and had never received it. When he pressed the issue at a board meeting, Margaret had become hostile and accused him of making unfounded accusations. Harold had resigned rather than continue fighting, a decision he now regretted. But Harold had kept copies of financial documents from his time on the board. When he met with Daniel and showed him these documents, the full scope of the fraud became clear. The parking management fees were being paid to a company called Desert Property Consultants, LLC. Harold had researched this company at the time and found that it was registered to an address that turned out to be a UPS store mailbox. The company had no website, no public presence, and no apparent employees other than its registered agent, Margaret Blackwood's daughter. The parking dispute was never just about parking. It was about Margaret creating a revenue stream through fake consulting fees paid to a shell company owned by her family, funded by HOA fees that every resident paid. The parking reassignments weren't just about getting Trevor a space. They were about creating the appearance of active parking management to justify the consulting fees. Daniel estimated that over 9 months, approximately $47,000 had been paid to Desert Property Consultants for services that were never actually provided. This was embezzlement, plain and simple. He amended his lawsuit to include claims of fraud and breach of fiduciary duty, and he shared the financial evidence with the Arizona Attorney General's office, which has jurisdiction over HOA fraud. The special meeting that Daniel had petitioned for was scheduled for a Thursday evening, 3 weeks after he filed his lawsuit. The turnout was unprecedented. 73 of the 92 homeowners attended, either in person or by proxy. The room was packed, the energy was tense, and Margaret looked like she was facing a firing squad. Under Arizona law, board members can be removed by a majority vote of homeowners present at a properly noticed meeting. Daniel had prepared a presentation laying out the evidence, the illegal parking reassignments, the financial irregularities, the pattern of retaliatory fines, and the fake consulting company. He presented everything methodically, showing documents on a large screen, citing specific statutes that had been violated, and explaining how every homeowner's money had been misused. Margaret's defense was to claim that she had been trying to professionalize the HOA's operations and that she had relied on expert advice for all her decisions. When confronted with the Desert Property Consultants' payments, she claimed she had been unaware that her daughter owned the company and that the management company had set up the arrangement. This explanation fell apart when Harold Chen stood up and testified that Margaret herself had proposed hiring the consultant and had personally approved every invoice. Have you ever seen someone's entire narrative collapse in real time? The vote wasn't close. By a margin of 68-5, the homeowners voted to remove Margaret and her 2 allied board members immediately. An interim board was appointed on the spot, consisting of Harold Chen and 2 other longtime residents known for their integrity. Their first act was to vote unanimously to restore Daniel's access to parking space 237, to void all fines that had been issued to him, and to launch a full forensic audit of the HOA's finances. but the special meeting was just the beginning of Margaret's problems. The amended lawsuit was moving forward, and Daniel was seeking not just restoration of his rights, but also damages for the months of harassment, stress, and legal fees he had incurred. More significantly, the Arizona Attorney General's office had opened a formal investigation into the financial irregularities. The forensic audit, conducted by an independent accounting firm, revealed that the embezzlement was even worse than initially suspected. Over the 18 months that Margaret had been in various board positions, including a year as treasurer before becoming president, approximately $93,000 had been siphoned out of HOA accounts through various schemes. Fake consulting fees, inflated vendor contracts where vendors kicked back portions of payments to Margaret, and even outright transfers to personal accounts that had been disguised as emergency maintenance expenses. The audit also revealed that Margaret had been issuing fines aggressively across the building, collecting over $48,000 in fine payments during her 9 months as president, nearly 10 times the historical average. Most of these fines were for petty or fabricated violations. Some of the fine money had been deposited into the fake consulting company's account. Margaret had essentially been running a protection racket, fining residents for minor issues and then offering to waive fines in exchange for not opposing her on other matters. Can you believe someone could be this brazen in defrauding their own neighbors? The evidence was overwhelming. Daniel shared all of it with the Attorney General's office, and prosecutors began building a criminal case. Margaret was eventually charged with theft, fraud, and misuse of homeowner association funds, all felonies under Arizona law. The building's attorney, who had been providing legal advice to Margaret's board, came under scrutiny as well. It turned out that several of his legal opinions supporting the board's parking reassignments and other actions were based on incomplete or misleading information provided by Margaret. In some cases, the attorney had warned that proposed actions were legally questionable, but Margaret had proceeded anyway and then misrepresented the attorney's advice to other board members. The attorney cooperated with investigators and provided documentation showing that he had repeatedly cautioned against the board's more aggressive actions. The management company also faced consequences. While they weren't directly involved in the fraud, the audit revealed that they had failed to provide adequate oversight and had processed suspicious payments without asking appropriate questions. Several homeowners filed complaints with the Arizona Department of Real Estate, and the management company was ultimately fined and required to implement enhanced oversight procedures for all the HOAs they managed. Trevor Blackwood, Margaret's son, became an unexpected witness for the prosecution. When confronted with evidence of his mother's crimes, Trevor claimed he had been unaware of the fraud and had simply believed his mother when she told him he could park in space 237. He agreed to testify about conversations where Margaret had discussed generating revenue from the HOA and had mentioned that she needed to put these lawyers and accountants in their place when residents questioned her authority. The criminal case moved forward, and Margaret's attorney attempted to negotiate a plea deal. Prosecutors were willing to consider reduced charges in exchange for full restitution and cooperation. Still, Margaret refused, apparently convinced that she had done nothing wrong and that she was being persecuted for trying to manage the HOA effectively. This decision to fight the charges would prove to be catastrophic. What happens when someone's delusion of righteousness meets reality? The criminal trial lasted 6 days. Prosecutors presented the financial evidence, the testimony from Harold Chen and other board members, the falsified invoices, and the trail of money flowing from HOA accounts to Margaret's daughter's shell company. They showed how Margaret had systematically abused her power to retaliate against anyone who questioned her, with Daniel being the most prominent, but far from the only victim. The defense strategy was to claim that Margaret had made mistakes, but had no criminal intent. Her attorney argued that she had been trying to modernize the HOA's operations and had relied on bad advice. This narrative was undermined by the prosecution as evidence of Margaret's own handwritten notes discussing how to maximize fee revenue and shut down troublemakers. In one particularly damning note, Margaret had written, "Daniel Rodriguez needs to be made an example of," next to calculations of how many fines could be issued before triggering member revolt. The jury deliberated for less than 4 hours before returning guilty verdicts on all counts. Margaret was convicted of theft, fraud, and 15 counts of misuse of homeowner association funds. She faced up to 7 years in prison, though sentencing guidelines suggested she would likely receive a shorter sentence given her age and lack of prior criminal history. The criminal conviction was just one part of the resolution. The civil lawsuit that Daniel had filed proceeded separately, and the evidence from the criminal trial made the civil case a slam dunk. The HOA's insurance carrier, after examining the evidence, made a settlement offer to avoid the expense and publicity of a trial. The settlement included full restoration of Daniel's rights to parking space, 237, vacation of all fines issued against him, payment of all his attorney fees, which exceeded $60,000, payment of $150,000 in compensatory damages for harassment, emotional distress, and interference with property rights. A written apology was published in the building newsletter and posted in common areas. Implementation of new governance policies to prevent future board abuse. Daniel accepted the settlement. The money was substantial, but what mattered more to him was the systemic change. The new governance policies included requirements for independent audits, term limits for board members, mandatory training on fiduciary duties, and enhanced financial oversight. The settlement also required the HOA to hire a professional management company with a stronger reputation for compliance and oversight. But what about Margaret? The criminal sentencing hearing was held 3 months after the conviction. Prosecutors sought a prison sentence, arguing that Margaret had betrayed the trust of her neighbors, stolen nearly $100,000, and shown no remorse. The defense argued for probation, citing Margaret's age, her lack of criminal history, and her claimed health issues. The judge was not sympathetic. In a lengthy sentencing statement, the judge noted that Margaret had been in a position of trust and had systematically abused that trust for personal gain. The judge emphasized that HOA board members have fiduciary duties to the community and that betraying those duties is a serious crime. Margaret was sentenced to 4 years in state prison, with credit for time served and the possibility of parole after serving 2 years. She was also ordered to pay full restitution of $93,000 to the HOA, plus additional restitution to individual homeowners who had paid improper fines. Margaret's daughter, who owned the Shell Consulting Company, was charged separately with participating in a fraudulent scheme. She eventually pleaded guilty to conspiracy and was sentenced to 18 months in prison, suspended in favor of 3 years probation and an order to repay $37,000 of the money that had flowed through her company. Trevor Blackwood was not charged, having cooperated with prosecutors and demonstrated that he was merely a pawn in his mother's schemes rather than an active participant. He moved out of Riverside Towers shortly after his mother's conviction, reportedly to avoid the judgment of neighbors who knew the full story. The forensic audit's findings led to restitution for multiple homeowners who had been targeted with improper fines. The interim board created a restitution fund using the recovered embezzled money, and 23 homeowners received refunds totaling over $40,000. The board also voted to reduce HOA fees by $50 per month for a year, returning money to the community after eliminating the wasteful spending and fraudulent charges. What were the long-term impacts beyond the immediate resolution? The Riverside Towers case became something of a landmark in Arizona HOA law. The Arizona legislature, prompted in part by publicity around the case, passed new legislation strengthening homeowner protections and increasing penalties for HOA board members who misuse their positions. Key provisions included mandatory training for all HOA board members on fiduciary duties and legal compliance, requirements for annual independent financial audits for HOAs with more than 50 units, enhanced disclosure requirements for any business relationships between board members and HOA vendors, clearer procedures for homeowners to challenge fines and board decisions, increased penalties for HOA board members who retaliate against homeowners who exercise their legal rights. The legislation was informally nicknamed Daniel's Law by some advocates, though the official title was more bureaucratic. Daniel was invited to testify before the legislature during consideration of the bill, and his testimony about his experience was compelling and influential. The case also had ripple effects in the legal community. Daniel wrote a detailed article for the Arizona Bar Journal about HOA governance and property rights, using his case as a teaching example. The article became one of the most read pieces in the journal is Recent History and was cited in several subsequent court cases. Daniel also received numerous calls from other homeowners facing similar HOA disputes, and his law firm expanded its HOA litigation practice as a result. For Riverside Towers itself, the transformation was remarkable. The new board, led by Harold Chen, operated with a level of transparency and professionalism that was a stark contrast to Margaret's regime. Board meetings were well attended, financial statements were posted online for all owners to review, and decisions were made through genuine discussion and debate rather than rubber stamping a president's dictates. The building developed a stronger sense of community as residents realized they could participate in governance without fear of retaliation. The parking situation was fully resolved. All deeded parking spaces were restored to their rightful owners. The 7 homeowners who had been improperly displaced from their spaces received apologies and compensation for their months of inconvenience. The visitor parking rules were clarified and fairly enforced. Space 237 remained Daniel's undisturbed, a small but significant symbol of property rights protected. But what about Daniel personally? How did this experience change him? While he had won a complete victory, the 9-month ordeal had taken a toll. The constant stress of harassment, the financial burden of mounting a legal defense, which was only later reimbursed, and the emotional energy of fighting an unjust system had been exhausting. Daniel later described the experience as both empowering and draining. Empowering because he had the knowledge and resources to fight back effectively, but draining because he knew most people wouldn't have been able to do what he did. This realization led Daniel to establish a pro bono program at his law firm specifically focused on helping homeowners facing HOA abuse. The program provides free or reduced-fee legal assistance to homeowners who can't afford full-rate legal representation. In the first year of the program, Daniel's firm helped 15 families successfully challenge improper HOA actions, recovering over $200,000 in improper fines and fees. Daniel also became active in homeowner advocacy organizations, speaking at seminars and conferences about property rights and HOA governance. He developed a reputation as one of the leading voices for HOA reform in Arizona, and his expertise was sought by legislators, journalists, and other attorneys handling similar cases. The experience also changed Daniel's relationship with his own home. What had been a sanctuary had become a battlefield, and even after the victory, there were emotional scars. He considered selling the condo and moving somewhere without an HOA, but ultimately decided to stay. The community had been transformed, and he felt a sense of ownership, not just of his property, but of the successful fight to reclaim the HOA from abuse. His presence in the building served as a reminder that residents have rights, and that those rights are worth defending. 5 years after the parking space war began, where do things stand? The transformation of Riverside Towers has been complete and lasting. The building operates with a professionalism that would have been unthinkable under Margaret's regime. Annual audits are conducted religiously, board elections draw competitive candidates who actually want to serve the community rather than wield power, and the culture has shifted from one of fear to one of genuine community engagement. Harold Chen served as HOA president for 3 years after the crisis, establishing systems and norms that have endured beyond his tenure. He implemented quarterly town halls where residents can discuss issues and concerns in an open forum, rather than the perfunctory annual meetings that had been the norm. He established committees for different aspects of building management, maintenance, social events, and financial oversight that allow residents to participate meaningfully in governance without requiring full board service. The building's financial health improved dramatically once the corruption and wasteful spending were eliminated. The reserve fund, which had been dangerously depleted under Margaret's management, was rebuilt to appropriate levels. Several long-deferred maintenance projects were completed, including renovation of the lobby and upgrades to the building's aging HVAC system. Property values in the building increased notably, outpacing comparable properties in the area, as word spread that Riverside Towers was well managed and financially sound. Margaret Blackwood served 26 months in prison before being released on parole. She emerged from incarceration financially ruined. The restitution orders had forced the sale of her condo, and most of her retirement savings had gone toward legal fees and court-ordered payments. She moved to a different state to live with relatives, leaving behind the community she had once dominated. According to those who maintained contact, she never truly accepted responsibility for her actions, continuing to view herself as a victim of overzealous prosecution and ungrateful neighbors. Her daughter completed probation and also relocated, having lost her job and facing difficulty finding employment with a criminal conviction on her record. Trevor Blackwood, the son whose parking situation had inadvertently sparked the entire conflict, maintained a low profile and severed ties with his mother, reportedly still traumatized by the revelation of her crimes and the public humiliation of the trial. But let's talk about the broader impact beyond just one building. The Riverside Towers case became a cautionary tale that spread throughout Arizona's HOA community and beyond. Property management companies began implementing stronger oversight procedures, knowing that they could face regulatory consequences for failing to catch obvious fraud. HOA board members in other communities heard the story and reconsidered how they exercised their authority, understanding that abuse of power could have serious legal consequences. The case was featured in multiple continuing legal education seminars for attorneys, training sessions for property managers, and even in some real estate law courses at Arizona State University's law school. Daniel was invited to speak at several of these events, and his presentation, titled "When Property Rights Meet HOA Overreach, a Case Study," became a popular session at legal conferences. The media coverage of the case sparked broader conversations about HOA governance reform nationwide. Articles appeared in the New York Times, the Wall Street Journal, and other national publications exploring the question of whether HOAs have too much power and insufficient oversight. Several states, inspired partly by Arizona's legislative reforms, began considering their own HOA reform legislation. Consumer advocacy groups added HOA abuse to their list of priority issues. Daniel's pro bono HOA assistance program grew into a small nonprofit organization called the Homeowner Property Rights Project. The organization provides not just legal assistance, but also education, helping homeowners understand their rights and HOAs understand their legal obligations. The organization's website features resources, including template letters for challenging improper fines, explanations of homeowner rights under state law, and a directory of attorneys who handle HOA cases. The project has handled over 200 cases in its 5 years of operation, with a success rate of about 75% in achieving favorable outcomes for homeowners. These outcomes range from fines being waived to board members being removed to settlements compensating homeowners for damages. The organization estimates it has helped recover over $3 million in improper fines and fees, prevented dozens of improper liens and foreclosures, and assisted in the removal of numerous abusive board members. What lessons emerged from this entire saga? Daniel often reflects on this question when he speaks about the case. Several key themes emerge. First, documentation is everything. Daniel's meticulous record-keeping, photographing violations, saving every email, recording meetings, creating comparison data, was essential to building his case. Many homeowners facing similar situations don't document systematically, making it much harder to prove patterns of abuse or to challenge specific actions. Daniel now advises anyone in an HOA dispute to start documenting immediately and comprehensively. Second, legal expertise matters enormously. Daniel's background as a real estate attorney gave him advantages that most homeowners don't have. He knew what laws applied, he knew how to research property records, he understood legal procedures, and he could represent himself effectively. Most importantly, he knew that the HOA's claims about having authority to reassign his parking space were legally baseless. A homeowner without this knowledge might have complied, believing the HOA had legitimate authority. This disparity troubles Daniel, and it's a major reason he established the pro bono program. The fact that vindicating one's property rights often requires expensive legal representation means that justice is effectively available only to those who can afford it or who happen to have relevant expertise. The reforms that came out of the Riverside Towers case attempted to address this by creating clearer procedures for homeowners to challenge HOA actions, but significant barriers remain. Third, HOA boards desperately need checks and balances. Margaret's ability to operate with impunity for 9 months stemmed from a lack of meaningful oversight. She controlled the board through allied members who didn't question her. The management company provided administrative support but didn't scrutinize financial decisions, and most homeowners were too busy or intimidated to challenge her. This combination allowed corruption to flourish. The reforms implemented at Riverside Towers and later embodied in state legislation, mandatory audits, term limits, enhanced transparency, address this structural problem. Fourth, retaliation is real and must be addressed. Margaret's escalating campaign of violations and fines against Daniel after he began challenging her authority was a textbook case of retaliation. This kind of response is unfortunately common when homeowners stand up to abusive boards. The legal reforms that emerged from the case include stronger protections against retaliation, but cultural change is needed as well. Board members must understand that disagreement and challenge are healthy parts of democratic governance, not threats to be punished. Fifth, the stakes in HOA disputes are often higher than they initially appear. What began as a parking dispute revealed systematic embezzlement, widespread fine abuse, and governance failures that affected the entire community. This pattern repeats in many HOA cases. What looks like a petty dispute over rules often masks deeper problems with how power is being exercised and how community resources are being managed. How has the experience shaped Daniel's view of HOAs more broadly? He's developed a nuanced perspective that rejects both the HOAs are inherently evil narrative and the HOAs are necessary for property values defense. Instead, he views HOAs as governance structures that can work well or poorly, depending on how they're run and how accountable the leadership is to the community. Well-run HOAs, Daniel argues, provide genuine value. They maintain common areas, enforce reasonable standards that do protect property values, provide amenities that individual homeowners couldn't afford alone, and create frameworks for neighbors to resolve disputes. The problem is not the concept of shared governance, but rather the lack of adequate safeguards against abuse when bad actors gain control. Daniel points to Riverside Towers itself as proof that HOAs can work. Under the reformed governance structure, the building's HOA functions effectively and without drama. Decisions are made transparently, finances are managed responsibly, rules are enforced fairly and consistently, and residents feel they have a genuine voice in how their community is run. This transformation didn't require eliminating the HOA. It required eliminating the conditions that allowed abuse. But Daniel also acknowledges that the current legal and regulatory framework for HOAs is often inadequate. In many states, HOAs operate with minimal oversight, homeowners have limited practical recourse against abuse, and the power imbalance between boards and individual owners is significant. He advocates for continued reform, including stronger state-level oversight, easier paths for homeowners to challenge improper actions, and meaningful penalties for board members who violate their fiduciary duties. What about the emotional and personal toll? This aspect of the story doesn't always make it into the legal analysis or the policy discussions, but it's deeply significant. Daniel admits that the 9 months of active conflict with Margaret's board were among the most stressful of his life. The constant violation notices, the threat of losing access to his property, the accumulating fines, and the uncertainty about how far Margaret would go created persistent anxiety that affected his sleep, his work, and his overall well-being. Even after the victory, recovery took time. Daniel found himself checking his mailbox with apprehension for months, half expecting another violation notice even though Margaret was gone. He had difficulty fully relaxing in his own home, having spent so long in a state of vigilance. He eventually sought counseling to process the experience, something he wishes he had done earlier in the conflict. This emotional dimension is important because it highlights why many homeowners choose not to fight back against HOA abuse, even when they have legitimate grievances. The personal cost of sustained conflict is significant, and not everyone has the emotional resources or support system to endure it. Daniel's story is inspiring in many ways, but it's also a reminder that standing up for one's rights should not require this level of personal sacrifice. The establishment of the Homeowner Property Rights Project was partly motivated by a desire to make it easier for others to fight back, to provide support and resources so that homeowners facing similar situations wouldn't have to endure what Daniel did. The organization provides not just legal assistance, but also emotional support, connecting homeowners facing HOA disputes with others who have been through similar experiences. Where does the parking space dispute stand in the broader landscape of property rights? This question fascinates legal scholars who have studied the case. At its core, the Riverside Towers case was about a fundamental principle. Property ownership means something. When Daniel purchased his condo, the deed clearly included parking space 237. That wasn't a courtesy or a privilege that could be revoked. It was a property right as legally enforceable as his ownership of the condo itself. Margaret's attempt to reassign that space was, in legal terms, an attempted taking of private property without just compensation, which is prohibited by both the Fifth Amendment to the U.S. Constitution and similar provisions in state constitutions. The fact that it was an HOA attempting the taking rather than a government entity does not eliminate the legal problem. HOAs are bound by contract law, property law, and their own governing documents, none of which gave Margaret authority to reassign deeded parking spaces. The case reinforced important precedents about the limits of HOA authority. HOAs have broad powers to enforce rules, maintain common areas, and regulate certain aspects of property use, but those powers don't include the ability to override fundamental property rights. This distinction is crucial because HOAs sometimes act as though their authority is unlimited, particularly when dealing with homeowners who don't know how to push back. Several subsequent court cases in Arizona and other states have cited the Riverside Towers case when analyzing the scope of HOA authority. The case has become a touchstone for the principle that HOAs must respect property rights and cannot use their rulemaking or enforcement powers to confiscate or reassign property that homeowners actually own effectively. What about the financial fraud aspect? This component of the case is equally significant from a legal perspective. HOA board members are fiduciaries, meaning they have legal obligations to act in the best interests of the homeowners they serve, to manage HOA resources responsibly, and to avoid conflicts of interest. Margaret's creation of a shell company to receive HOA payments was a textbook violation of these fiduciary duties. The financial fraud aspect of the case led to increased scrutiny of HOA finances across Arizona and beyond. Auditors and regulators began looking more carefully at vendor relationships, consulting arrangements, and unusual payment patterns. Several other cases of HOA embezzlement were uncovered in the wake of the Riverside Towers investigation, suggesting that Margaret's crimes were not as unique as one might hope. The reforms that emerged, mandatory audits, Enhanced disclosure requirements, penalties for conflicts of interest, were designed to make this kind of fraud harder to perpetrate and easier to detect. But as Daniel often points out in his presentations, the most important safeguard is an engaged membership that pays attention to how their money is being spent and isn't afraid to ask questions when something doesn't look right. 10 years from now, what will be the legacy of this case? It's still early to make definitive assessments, but several lasting impacts seem likely. First, the case will continue to be cited in legal disputes about HOA authority and property rights. The clear articulation of the limits on HOA power and the consequences for overreach will influence how similar cases are decided for years to come. Second, the governance reforms implemented at Riverside Towers and later adopted by many other HOAs represent a genuine improvement in how these organizations operate. Increased transparency, enhanced financial oversight, and stronger protections against retaliation all make HOA governance more democratic and less prone to abuse. These reforms may seem like common sense in retrospect, but they weren't standard practice before cases like Riverside Towers demonstrated their necessity. Third, the case helped spark a broader conversation about HOA reform that continues to evolve. Legislators, consumer advocates, and homeowners are increasingly aware of the potential for HOA abuse and the need for stronger safeguards. This awareness is translating into policy changes at the state and local levels, though progress is gradual and uneven. Fourth, the Homeowner Property Rights Project and similar organizations represent a new infrastructure for supporting homeowners in HOA disputes. By providing legal assistance, education, and community support, these organizations help level the playing field between individual homeowners and institutional HOA structures. This support network didn't exist before, and its development is a direct legacy of cases like Riverside Towers. And what about Daniel himself? He still lives in Riverside Towers, still parks in Space 237. The condo that was once a source of stress is again his sanctuary. He continues to practice real estate law, with HOA litigation remaining a significant part of his practice. He serves on the board of the Homeowner Property Rights Project and speaks regularly about HOA reform. But most significantly, Daniel has become a voice for the principle that standing up for one's rights matters, even when it's difficult, even when the path is uncertain, and even when the personal cost is high. His story demonstrates that individuals can challenge institutional power successfully when they combine knowledge, persistence, documentation, and courage. The parking space war that went nuclear ended with justice served, corruption exposed, and a community transformed. It's a reminder that sometimes the most important battles are fought not over grand principles in abstract, but over concrete things like parking spaces. And that's how we handle these disputes says something profound about whether we truly believe in property rights, democratic governance, and accountability. So what's the final takeaway from this entire saga? It may be this: your property rights matter. Your voice in your community matters. Documentation matters. Knowledge matters. And sometimes refusing to back down in the face of injustice can create change that extends far beyond your own situation. Margaret Blackwood thought she could use her position to take what didn't belong to her, to punish those who questioned her, and to operate without accountability. She was wrong. Daniel Rodriguez understood his rights, documented the abuse, built his case methodically, and pursued justice relentlessly. He was vindicated. The parking space was never just about parking. It was about the principle that property ownership means something, that rights are worth defending, and that no one, not even an HOA president, is above the law. And in the end, that principle prevailed. The question for anyone facing similar circumstances isn't whether fighting back is easy. It's not. The question is whether your rights are worth defending. For Daniel, the answer was clear. And because he answered that question with action rather than submission, an entire community is better off. State laws are stronger. And homeowners across the country have a powerful example of what's possible when you refuse to accept injustice. What would you do if your HOA tried to take your property? Would you have the courage to fight back? Would you document everything? Would you seek legal help? Would you organize your community? These aren't hypothetical questions. They're choices that thousands of homeowners face every year. The Riverside Towers case proves that fighting back can work, that justice can prevail, and that one person's stand against abuse can create ripples that transform entire systems. The parking space war went nuclear, and when the dust settled, the good guys won.